first item on our agenda is the attorney chat quasi-judicial refresher. We'll hear from staff.
Thank you, members of council. This is primarily just a refresher. These are mostly things we've talked about before, and Councilmember Johnson heard about some of these at CML. What you have in front of you is a presentation from CML on quasi-judicial proceedings, and I'm not suggesting you're doing anything wrong, but there are a couple of things that we might be able to do a little better. So we'll try and talk about those tonight. And then the first half will be a refresher of things we've talked about before. The second half, where we talk more about deliberations, is some stuff that maybe we haven't spent enough, or I haven't spent enough time with you on in the past, things that we can do to make your decisions what I refer to as more bulletproof. So, practices for quasi-judicial. I mean, we all know that your quasi-judicial decisions are important. They involve property claims, rights of parties to develop, things like that. They also, because there is so much at stake, they present the greatest risk of liability and challenge. So these are the rules of engagement, and disclaimer, this is not my work product. This is stuff that Sam Light has put together. Sam Light is general counsel for CIRSA. For years, he was the city attorney for the city of Louisville, and pretty well respected in the area. So I really can't take credit for the work product here. But you know, due process and elected officials' roles, due process is what this is all about. Somebody that comes in front of you for a quasi-judicial proceeding is entitled to, constitutionally, to due process. And that's a notice and an opportunity to be heard by a fair and impartial tribunal. And that's where you guys come in. You're the fair and impartial tribunal. I think one thing that I'm going to suggest we start doing to make it clear when you are in a quasi-judicial and other primarily legislative session is we're probably going to start marking your agenda items as these are quasi-judicial, just to kind of get you in the frame of mind for that. So we've talked before about the legislative role. This is really nothing new for you. Talk to everybody you want to about a legislative matter. Get all the input you can from third-party sources. Talk among yourselves outside meetings. When you're in a legislative role, you want to get all the information you can even before you come to the meeting, and then develop it more at the meeting. The antithesis of that is the quasi-judicial role. So we've talked about before, how do you know you're in a quasi-judicial role? Well, if you have a specific person or a specific piece of property in front of you, and you have a set of criteria in front of you, and you're being asked to decide whether this person or piece of property satisfies these criteria, then you're in a quasi-judicial role. If there aren't established criteria and it's not applying to a specific person, then you're in a legislative role. And I think that in the past we've talked about you wear many hats. To emphasize the distinction, I would suggest that you consider thinking of yourselves when you're a legislator as wearing a legislative hat, and when you're in a quasi-judicial position, think of yourself as wearing a judicial robe. So do you have your hat on? Do you have your robe on? If you have your robe on, you're in a quasi-judicial proceeding, and that usually involves an applicant who has notice of the hearing, and usually often includes a public hearing. So, but we've been through those before, and as I say, it all has to do with honoring due process, the constitutional right to due process before a fair and impartial tribunal. Sam provided these rules of engagement, think like a judge. I guess my suggestion would be to think like a judge and to act like a judge. I think that it's the actions that often get counsel in trouble as much as their thought processes. So he has a list of things to do. Don't make up your mind before the hearing. Don't make prejudicial pre-hearing statements. And I would add to that right in about that point in the bullet point, don't even have pre-hearing thoughts. If you can really just wait until you get to the hearing to think about it, to decide how you feel about it, that's what you should be doing. Once you start thinking about, okay, this is on the agenda tonight, and this is how I feel about it, you've started considering things that are not part of the hearing. You should not start your thought processes until the hearing commences, and you should decide it only based on what you see, hear, think, decide during the hearing. So, don't speak with one side or the other before a hearing. That's ex parte contacts. Don't participate if you have a financial or personal interest. We know that one. Don't sign any pro or con petitions. Don't even take a pro or con position or state of mind. I think that's even more important. Don't bring your decision-making facts you know to be true, but that aren't part of the testimony. And don't be a witness, prosecutor, advocate, or investigator. And we'll talk a little bit more about that. Part of what caused me a little bit of concern, and I was actually reaching for the button at the last meeting a little bit, is I heard some statements like, well, I talked to a lot of my friends and this is how they feel about it. Talking to your friends about a quasi-judicial matter is not part of the hearing, unless your friends showed up and testified at the hearing. So any discussions that you have with anyone, friends, families, applicants especially, is an ex parte communication and should be avoided. I think the other statement I heard was, historically back in 1857, it's not quite the year, but historically I remember when we talked about this once before, and this is what we did. What the council did on a previous occasion is not part of the hearing, so it shouldn't be considered. Now, how do you disregard what you know happened historically? Well, it may be difficult to put out of your mind. If you don't think you can, then you need to let me know so I can explain to the parties that are in front of you, look, there's some historical context. This is what was understood from before, and talk about it. And if a council member is not able to disregard what they remember historically, and the party objects, they may have to not participate in that hearing. If we disclose what happened historically and nobody objects, then you can go ahead. But I would caution you against the historical statements because they are not part of a quasi-judicial proceeding. Legislative decisions, they're fine. This is what we did last time we talked about RVs. This is what we're going to do this time we talk about RVs. But if it is a land use application, and this is what we did last time we did this land use application, that's not part of what's in front of you. So you really need to limit it to what's in front of you. As I say, think like a judge is part of it, but I think that acting like a judge is just as important as thinking like a judge. And it really is, a matter of just thinking, if I'm doing this in relation to a particular application, would a judge do that? If he's hearing a traffic accident case, would he go out there and try and recreate the accident? Would he go back to the scene and visit it? And they wouldn't. Their job is to sit in the courtroom and wear the robe and have the parties bring everything that's relevant to the judge's decision to the judge. And you're judges. So everything that's relevant to you needs to be brought to you by the parties. Rules of engagement, running a good hearing, I don't really have anything to add there. I think you guys do a great job of running a hearing. I think there's some good suggestions here about watch the back and forth discussions during quasi-judicial hearings. And one thing that I wanted to mention, and this applies actually to not just quasi-judicial, but to all things, we've seen several of our municipalities, and it's human nature. You have a meeting and you have a hot topic on the agenda, or maybe you don't, it's not even a hot topic. We are seeing more pre-meeting meetings and post-meeting meetings. So if you show up for a meeting and you have a discussion and it's on the agenda, and then you adjourn, and then you stand around, even on a legislative matter, and there's more than two of you, and certainly on a quasi-judicial matter, if you're talking about policy of the city, that violates open meetings laws. So my recommendation is it sort of all happens at the door. When you come to the meeting, you don't have a discussion among yourselves before you're on the record. Once you walk through the door. And likewise, when you're through with the meeting and you have adjourned, avoid the post-meeting meetings because that is technically an open meeting if there are more than two of you and you're talking about a matter of public policy. As far as ex parte communications, we've talked about those ad nauseum. The problem is really the ease of slipping into ex parte negotiations or looking at things that are outside the hearing is getting easier and easier. It is you're sitting there saying, I'm not sure where this is. I want to get oriented. So you pull up your phone and you do Google Maps. You say, oh, now I know where that is. That's outside the hearing. If you want to, you're working with a developer in a land use application. Well, I want to know more about this developer, so I'm going to Google him. It's outside the hearing. So again, if you have questions, if you say, I'm not sure where this is, applicant, can you orient me? Then it's part of the hearing and everybody has the same information. Or if you say to the developer, tell me more about your background and your experience during the hearing, then it's all part of the hearing and it's fair game because everybody hears it. But really try to avoid Google and Google Maps and all those things. We've even had meetings where people, because of live streaming, were not in this council, but on some of our elected bodies, where they will be live streaming the meeting, and at the same time they're getting texts from constituents about what they're considering. And that's okay in a legislative matter. But if you're in a hearing, that's a pretty blatant example of an outside the hearing influence if you're getting a text from somebody who's not even there. So just be careful of those. Let's see. Yeah, on this slide, the only thing I wanted to point out on this one, because this is more on ex parte communications, and this is just going over things we've said before, but there's this last bullet point that says, consider having a short explanation or FAQs on quasi-judicial process on your website. If you want us to put together a short blip on quasi-judicial items, especially if they're going to be marked on your agenda, this is a quasi-judicial item, we could either put it on your website, we could put it at the bottom of your agendas, just to explain to people, these are items that the council cannot discuss with you except during the hearing. We'll be glad to do that. If it's not a problem for you, we don't need to. But if you're getting approached on a lot of things, a lot of land use applications in particular, outside council meetings, then we probably should put that on there. So summing up contrasting roles, I think we've talked about these before. If it's legislative, get all the information you can before, during, and after. If it's quasi-judicial, just get it during the hearing. So the next part I want to spend a little bit more time on is this decision-making deliberations matter. I think we've talked about all of the issues I just brought up previously, but we haven't really spent time on deliberations. And frankly, that's probably my fault. Because let's assume you conduct that perfect hearing and there's no ex parte communications, there's no outside influences, then you're in a position to make a really good decision. But we need to make a really clear record of how you got to that decision. And that's what this decision-making deliberations is all about. You have the criteria in front of you, and I think we need to emphasize a little bit more about, yes, they satisfy all those criteria, but what is it that you heard during the hearing that makes you think this particular criteria was satisfied and that particular criteria was satisfied? And it may be as simple as having a discussion that, from the outset, you don't have to go through each of them laboriously. But if there are 5 criteria and you say it from the beginning, well, I think that criteria A, B, and E are clearly satisfied. They're not an issue here. So it's just C and D that we really need to talk about. That's great. And I would encourage you to say, well, here's why I think criteria C is satisfied. And this is obviously after you've closed the hearing, you've heard from staff, you've heard from the public, you've heard from the applicant, and you're to the point of talking amongst yourselves. But really try and focus on what are the issues that are disputed. And then once you identify them, really spell out what it is you think the evidence did or didn't show as far as those criteria. Just because there is an argument presented by the applicant or an argument presented by staff, you don't have to accept that. The instruction I used to give jurors was, you are the determiners of the fact. You can choose to believe all of the testimony and statements of a witness or none of it or some of it. So sometimes there is this tendency to think, well, they told us that, so we're bound by that. If they told you that, but there are other things that make you think that that may not be accurate or fully accurate, That's your determination to make. That's credibility. That's the things that you're here to determine. So just because you have it in the hearing doesn't mean that you have to go by it. Now, the flip side of that is you can't make a finding if there is no evidence to support it. If there is absolutely no evidence to support a specific criteria, you can't fill it in for the applicant or staff or whoever is responsible for satisfying that criteria. So you have to make sure that there is some evidence, but the weight that you give to that evidence is up to you to decide. I'm not sure I understand this particular illustration, but I was going to ask Sam about it, and I didn't get a chance to, about what the upside down house means. So I'll come back to you once I find that out. Oh, okay, considering effects. Okay. And then this deliberations matter, the rule of why, I think is part of that discussion. Once you get down to these are really the crux issues, these are the two that we think are disputed, then once somebody says, well, I think this criteria is satisfied, it's fair to ask, well, why do you think it's satisfied? And that's what this question of why is all about. It's not sufficient just to say it meets our standards or it doesn't meet our standards. You need to say why it does or doesn't. And then you also need to try and make your discussions in terms of what the evidence shows. Statements like I think or I feel are problematic. Statements like I saw this particular piece of evidence as supporting this particular criteria, those are helpful. So the last bullet point here, take the time you need to prepare the proper decision document. That's our responsibility as your legal counsel again. If you've had the discussion and you think that the resolution we've given you or the ordinance we've given you really doesn't do the justice to your determinations, you can do one of two things. You can either continue the matter and direct staff to prepare a resolution or an ordinance that does, or we can just take a brief recess. I don't want to date myself, but when I first started doing this, resolutions and ordinances were typed on a manual typewriter with carbon paper. And so you know how many copies you needed determined by how many pieces of carbon paper you had. And if you had to change an ordinance or a resolution during those meetings, that was a problem. But it's not a problem anymore. So if we have provided you something that you think needs to be revised, tell us. We'll take a brief recess, or you can go on with your other business and we can come back to it. I guess my message is we want to make sure that it completely reflects your decision. And it's not just that, you know, we're trying to make you guys look good. My job is to make sure that your decisions are as bulletproof as we can make them. And putting in there the exact reasons for your decisions is part of that. When one of your decisions gets appealed, and I think maybe this is one reason that we've gotten a little bit lax on some of the quasi-judicial hearings. You know, I think I've represented the city now for 10 or 12 years, and so far, none of your decisions have been successfully challenged. So that's great, but I'd like to keep it that way. And the standard is once you have made your decision, the reviewing court, they sue the city and it goes to the district court under what's called a Rule 106 appeal. The standard that that court is going to apply is unless you abused your discretion or it is without evidence to support it, they're going to go with your decision. And the reason for that is you were the ones that were here. You were the ones that heard all the evidence. You were the ones that determined what parts to accept and what parts not to accept. The reviewing court reads the record, but it doesn't observe the witnesses. It doesn't observe the exhibits. So they defer to you. And unless you did something fairly far out of bounds, and that would, again, fall probably on my shoulders if you were getting that far out of bounds, they will defer to your decision. So if we can make sure that we have a, you know, what I refer to as a bulletproof decision by you guys, then I'm not too worried about, you know, defending that if and when it goes to court. So I think that's really, those were the main issues that I wanted to talk to you about. I think you guys have done a great job in the past. I think there are things that we can work on in terms of marking your agenda, improving the ordinances and resolutions to make it real clear these are the criteria, and getting more input from you during the hearings on what you think satisfy or don't satisfy those criteria. But I'm also more than happy to answer any questions you may have. So,
Great. Thank you, Scott. Appreciate it. Questions, comments?
Provide just a little bit.
Absolutely.
Can you go back to that house that was upside down, Scott? So what Sam was getting at with this picture is reinforcing the importance of asking why and drilling down to a reason, right? So I don't want to approve this because I don't like it. Why? Well, because the house is upside down. Why? Well, it doesn't meet our design standards. And so continually asking why until you get to that really legitimate reason as to why you would vote something, why you would vote in a certain way. That's what Sam was trying to illustrate, and the power of why. Also, and Julie, correct me if I'm wrong, but we're currently in the process right now of incorporating new agenda management software. And in the agendas, there will be a portion on there that says, public hearing, and very clearly spell that out. So anytime you see public hearing, you'll know that business item is a quasi-judicial hearing, just to help prepare the council for what that conversation will look like and what the process will need to be that you follow.
and I think the final comment then on why, now that I understand the reason for the upside down house, this council, unlike some of the ones that we work with, does a really good job of not taking personal offense to somebody that disagrees with you. And I think the ability to really drill down on why requires that. So, I would encourage you to continue to be open-minded and thick-skinned all at the same time, because it's just that deliberative process that gets you to the best decisions. So, anyway, any other questions or comments?
I like the idea of adding the quasi-judicial to the agenda because it'll focus our attention that we have to be more mindful of what we're doing.
I also like the idea of probably adding a description for the citizens on the website, and then maybe even a link at the bottom of the agenda so that they can just click to it.
Okay.
That way they understand what the Latin means.
Okay. Yeah. And I've told you before, feel free to use me as an excuse if people try and talk to you about quasi-judicial stuff. Just tell them that the attorney said we can't talk about it until the hearing. Tell them we'd love to hear from you, but we can't hear from you except during the hearing. So, all right. Thanks.
Thanks, Scott.
I feel like I just lectured my bosses, and that's never a good thing.
No, yeah, it's Scott. It's always good to get these updates and reminders. Sometimes we do have some preconceived, notions probably, and sometimes we just kind of forget what kind of, legislative body we are versus the, the quasi-judicial, and it's good to get those refreshers out. Appreciate that. All right. Next item on our agenda is the Recreational Vehicle Ad Hoc Committee update, and I will give this over to staff and Councilmember Crabtree.
Mayor, council members. On the 25th of last month, we had an ad hoc committee meet in the chamber, and we went over a great sum of information. In my opinion, it went really well. It went well. We started with, and used throughout a 2-hour conversation, PowerPoint presentation, kind of going over different looks, different scenarios. The purpose for that was to pull everyone's thought process out of their own property, but looking at the entire bubble and everything that we were trying to look at. Based on your feedback and your information, there was about 10 action items that we needed to discuss with the ad hoc committee. We had 2 of them that stuck, that we are still working on as a committee, and we'll come to a resolution with that. But the other 8, we were all in agreement with. It was simple things, and I'll leave it open for questions, but it's everything that we've been looking for. And then that conversation, there's a lot of people that are looking at that same thing. Other than that, we have a drafted ordinance that I'm going to review. It just showed up in my inbox, so I'll be able to look at that and kind of see. And then I expect one other meeting to go over the proposed ordinance with the ad hoc committee and get their feedback and then present it to council. So I know that was a 30-minute slotted conversation, but I'd like to leave it open for questions if you have any. I didn't expect this to take 2 hours on the 25th, but it was a great conversation, and a lot of the ad hoc committee members added some value to it. All of it was valuable, but some other ideas that we did not have. The two sticking points that we are still identifying and addressing are the number of units on a piece of property and the size of the units. Other than that, we're pretty much in alignment, and I'm going to leave that in a gray area until the ad hoc committee and myself can go over the proposed ordinance and really make sure that we can present something that's beneficial for all of you. I can go over the 10 items real quickly if you'd like, but they're things that we've already talked about.
I'd like to hear them just for the public as well.
Perfect.
That's out here.
Perfect. So how I started the meeting is I utilized our information first. We discussed each item. Then after that, I gave the opportunity for anyone to add anything, and I added those items. Couple of quick items that we have, well, all 10 of them. All unlicensed trailers and RVs to be removed. Now these are my notes, so this is not verbatim. The staff took phenomenal notes and emailed that to me as well. That particular document we can go over as well if you'd like to. It is quite a lengthy one, but we discussed all licensed or how to address unlicensed trailers and RVs. A sticking point was limiting the amount of trailers, boats, and RVs based upon size. The sticking point to that was a good argument, and we'll probably not add that to the ordinance. But again, we'll have that discussion. We all agreed that these units need to be parked on improved surfaces. Reasonable size restrictions was another sticking point. Those were the two sticking points. And the example would be someone having 2 or 3 full-size, and I call them assets, instead of constantly regurgitating boats, RVs, and trailers. We didn't want, the ad hoc committee really kind of voiced the concern that they would like to have the opportunity to have 2 full-size assets or 3 full-size assets on it and not really dependent upon the size of those assets. We all agreed upon we need to make sure that there's a grace period for loading, unloading, and maintenance. We also agreed upon no one should live in it, but then that also came up with giving some time frame. So if family and friends were coming into town or an unexpected situation took place, then you could use that as temporary housing, but very temporary. And a good idea came through with like a parks pass that you would register with the city and let them know that this is the situation and this is how long this is going to be taking place. We all agreed that we should not be using these as storage. One of the ad hoc committee members said junk storage. I think that's important. That really kind of releases the fact of trailers holding HVAC parts or old hot water heaters or things like that for a period. We need to give grace in this ordinance of some time frame, 24 hours, 48 hours. No unlicensed commercial work on RVs unless they have a business license. We all were pretty agree upon that. The licensed boat matching current residents of the dwelling, we're fine-tuning that particular item. And then we just talked about guests also being able to stay in the RV for a short period of time. The intent of this entire project is to create a standardization that, and we all agreed upon, that code enforcement could use something that if the police department or a neighbor called in that something was out of alliance, that the code enforcement officer could then have something to say, no, in this ordinance, this cannot happen. The city has, or the staff has done a phenomenal job with cross-checking against current ordinances. And there are a couple that have surfaced, and we're going to either make a decision of working those into this ordinance or just letting the other ordinance take that place. The example of that would be parking an RV on the rocks and letting the weeds come up through that. That is already an ordinance in place. So in this particular ordinance, it's unlikely that we'll have that in this because it's already an enforceable ordinance. But yeah, that's, in a nutshell, what happened on the 25th.
Any questions, comments?
Sounds like you made a lot of progress.
We did. I appreciated everyone's input. The ad hoc committee was great. Everyone on the committee really added value. There wasn't really any particular situations that we could not discuss, and everyone had an option and an opportunity at any point to really kind of chime in and add some items to it.
Do they feel, does the committee feel like they're making a definite impact? They're getting their voice heard in the committee. They're able to, comfortably, express their concerns and everything, and that's being taken into consideration as we.
In my opinion, I would agree that I would say yes, that everyone felt that they could speak at any point. I made sure that they had that opportunity. Again, I structured it in a way that we went over our looks and wants. We talked about each one of those items, showed examples. If we didn't agree upon it, then it actually became a sticking point to those two items. And if we did, then we put it down.
I know we've talked before, and I know that we've had discussions as council. I just want to ensure that the committee, being a citizen-driven committee, is making sure that they're feeling like their voice is heard and they're being part of the process. I don't want them to feel like this is a council-driven directive and this is what the council wants. And I know that sometimes that may come off from individuals that feel that way, that is this really what the council wants, or is this what the citizens really want? So I just want to ensure that we're making sure that the citizens are being heard and they are driving this and making sure that they're giving us the information for us to consider, not us dictating to them what the council itself wants. Because, if we want to do as a council, we could go down that road, but I really want to ensure that we're making sure the citizens are providing us the information that they want to see in the community.
Well, I believe that that's exactly what's happening. And as any successful business organization runs, there has to be some kind of structure and foundation to start with. And that information was given and presented, and everyone had the right to speak. Everyone could say yay or nay. I did not go to the granular level of saying, Mayor Clark, do you like this? Mayor Pro Tem, do you like this? It wasn't, but if someone didn't like it or wanted to have a discussion about it, people had the floor and they could actually speak upon that. There was a structure behind this meeting. It wasn't a free-for-all, just let's start throwing ideas out there or defending one thing or the other. We all have the same goal in mind of cleaning up this particular ordinance or creating this ordinance to create a more beautified Evans. And the foundation was there. We followed the foundation, and people could speak and add to it if at any point they needed to. It was a structured meeting, and people didn't step on each other's toes. We talked when we had the opportunity to. I never felt that anyone did not have the opportunity to talk. We kept on point, and we didn't drift a whole lot. And we'll go back to the meeting again, and they'll have a second opportunity to go over these items. But we have a pretty strong foundation, and a lot of our ideas are in alignment. A lot of the wants of City Council are in alignment to the ad hoc committee, which then would be in alignment to the citizens. I don't feel that this is a heavy burden, and we all agree that we don't want to cause any challenges or any longevities of our residents. But I do feel that everything was presented and people had the opportunity to participate if they so chose to, and I think everyone did.
Have you considered potentially, like, once, now that you've had a meeting, and then in essence get closer to what the goal is, bringing in the community at large, like maybe having a town hall to present in essence your findings of how you arrived to such language of the ordinance or such points, and then going back again and then kind of solidifying it, just so you have kind of a citywide kind of engagement. Have you considered that?
Not at all. Not at all. And that's why we have the ad hoc committee. So if people outside of the ad hoc committee would like to participate, they can come to an open hearing or I can host a town hall. But the feedback that we're building this is really with the ad hoc committee. And at any point, anyone can email me information and I can present it, but no. I have a time frame that I would like to get this done. And the more that we bounce here and go here might take additional time that no one wants.
What is that time frame that you're thinking?
I would like it done mid-August, so.
I think this might be a good idea is once the committee solidifies exactly what that ordinance is going to look like or could be, as it starts to get finalized, maybe doing a joint session with council and the committee, and that way we can just all, hey, get their feedback, hear from them, how their experiences working with council, what their thoughts, what their ideas, and kind of all put it together. I think that would be a great idea because it's always good to hear from committee members, planning commission, water sewer board, or even ad hoc committees to get their experience and how they felt through this whole process and kind of tie it all in together. So
In a work session?
in a work session, absolutely.
There you go, Cody.
So you're looking at a mid-August timeframe.
That's what I would like.
So what, maybe 2 or 3 more meetings? Maybe you're looking at?
Yeah, that would be appropriate.
So as we move forward, August 5th, now that we're in July, we're going to be hitting a lot of budget discussions. That'll be about an hour each. August 5th, which I think would be a little too early for that. We have a budget discussion for comp and class payroll recommendations. August 20th, we're going to have a budget discussion over supplies and services, and then I've also got a tentative discussion on here from the Greeley Transportation, or about the Greeley Transportation Plan. I could potentially, let's see, that's 45 minutes of both of those. That's about an hour and a half right there. How much time would you envision this discussion needing?
For a joint session between the two committees, I'd say I'd schedule it half hour, 45 minutes, just to make sure that we have an opportunity to have a good, meaningful discussion if that needs to be. I don't want to make it too short and just feel like the other voices weren't heard, but I also don't want to make it too long either. So I'd say 30.
So I can look at potentially rearranging some things for the August 20th, or we can have that discussion, the joint discussion on September 3rd.
But I would also maybe say September would be better, just in case there's issues that can't be resolved in the next 2 or 3 meetings that are possibly going to be had, and that way they could probably get worked through. I don't want staff rushing, and I don't want the committee rushing to make a decision if there's some sticking points that haven't been able to be resolved.
Sure.
So I know 2 to 3 meetings, probably mid-August, but I think maybe early September timeframe would probably be best.
So I think as we work through this, we can kind of determine where the committee's at, and then we can finalize what that date will look like, and then I'll schedule it and we can plan accordingly.
I would propose longer than 30 minutes, at least an hour.
Let's do 45. I think an hour. I think if the committee is doing the work that they are doing and what I hear that sounds like they're doing, I think that once they resolve those issues and get that draft ordinance to staff and they get to review it, legal review it, I think An hour might be possible, 45 minutes to an hour, but I wouldn't go any shorter than 30 minutes.
I just think it's just because we'll be seeing the final kind of product, and then we'll have questions, because we're not a part of, you know,
Right,
like
no, I
the-
agree. Let's go 45 minutes, and we'll, if it goes a little longer, we'll adjust as needed.
Because that meeting would slowly be for just presentation and then any closing ends, because the ad hoc committee would have already seen the official documentation, have already digested it, approved it, before it even comes up.
Right, and we would have questions.
Councilmember Neal, it looked like you were raising your hand.
Well, I think that, since Councilmember Crabtree thinks that, they can iron out the two sticking points in just one more meeting, that, the committee seems to be pretty much in agreement with what directions they wanna go.
And it's really gonna just become one sticking point, because I think we're gonna give the committee the other one and just let it go. And that would be, the number of units.
I would just say give the committee as much time as they need and whatever needs to be worked out, resolved and everything. But I think overall, it sounds like everything's going pretty good. And I'm looking forward to, I know there's a couple committee members in the audience right now. Thank you for your time. I appreciate all the hard work that you're doing for this. I do appreciate it. And I do look forward to what the final result is at the end of the next couple months or whenever that should be. So, thank you. But no, I'm looking forward to it. I appreciate the hard work that you're putting in the committee and everything, and I just look forward to whatever issues that need to be resolved, or if anything else comes up that needs to be incorporated to come into that. You know, like I said, I just want to make sure that we're hearing the voices of the citizens and not what council wants. That's all. Yep. Any other additional questions, comments? No?
So I'm gonna say thank you for taking this on and, you know, overseeing the ad hoc committee, and
Yeah, they're great people to work with, and they've got a lot of good ideas and good feedback. So,
awesome.
thank you.
Awesome. Great, thank you. All right, well, if there is nothing else, it's 6:42. We'll take a 18-minute break and we'll start promptly